Dito na bitawan mo. Bitawan mo.
Good morning, may Parricide. So, kumusta kayo? Medyo naantala tayo ng konti kasi lagi na lang tayo merong technical problem. Anyway, so yung lecture ni Ma'am Marie Rojan Padua ay medyo nagkaroon ng technical problem kasi pag-upload, walang sound. So, inaayos pa. Hopefully, mai-upload namin today kasi 2 parts ng videos niya. Part 1, 1 to 50, and part 2, yung 51 to 100. Okay. So, nariyan na ba ang Team Violet? Team Blue? How about Team Black? Team Green? Next, Team Cyan, Team Orange, Team Yellow, Team Red, and ano pa ba? Nakalimutan pa ba tayo? Hopefully wala tayong nakalimutan. Hindi na natin maalala makabisado lahat kasi masyado na tayong maraming teams. Okay? Ngayong araw, ang i-discuss natin ay continuation nung ating Revalida. Nalala nyo, nung season 1, meron tayong Revalida or final examination sa lahat ng subjects. So tapos na yung 5 subjects. Ang hindi pa lang natatapos ay yung Criminal Jurisprudence, Procedure, and Evidence. Okay? So, i-discuss yung 51. Although na-discuss na sa part 2, kaya lang naputol tayo last time. Kasi mahina yung signal. So, balikan natin yung 51. Then, up to 100 ang i-discuss natin today. Kumusta ang pag-review nyo? Handa-handa na ba kayo para sa ating board exam this year? So, gaya ng sabi ko before, walang ibang susi kundi ang sipag at tiyaga ninyo sa inyong pag-aaral. Okay? So, bago tayo mag-start, please i-share natin ang ating videos, ang ating live lecture today para mas tayong ma-reach na mga criminology students and their reviewees. Para kahit paano, sa ganitong paraan, ay makatulong tayo para kahit paano yung efforts natin ay at least nakakapagpalakas ng loob, nakaka-motivate kapag marami tayong mga tagapanood, maraming supporters. So, kumbaga yun na yung bilang kapalit ng mga pag-upload, yung panood ninyo. Para gusto kasi natin maging epektibo ang ating pag-review at gusto natin ay talagang makapasa kayo sa board exam at mag-top kayo sa board exam. Okay? So, i-share lang natin sa Homicide Criminology Review Group ang ating video. I-share din natin sa ating FB page, Attorney J.M. Peraro. Okay? So, huwag natin kalimutan sa mga hindi pa natin subscribers, please subscribe our channel, Attorney JMF Vlog. And please hit the notification bell para lagi kayong updated sa mga bagong lectures at mga bagong videos. Okay? So, by the way, meron tayong quiz number 2 sa Law Enforcement Administration mamayang gabi, 8:30 to 8:50 p.m. Bali, ang activities natin sa Law Enforcement Administration ay magtatapos sa July 3. Sa July 2 kasi is yun na yung after ng ating mga quizzes sa Law Enforcement Administration per subject, yung buong area ulit. Meron tayong board exam trial sa July 2, 2020. It is 8:30 to 10:30 p.m. Okay? Meron ulit ganun din pala. Ang top 1 ay makaka-receive ng 500 pesos. Top 2 ay makaka-receive ng 300 pesos. Top 3 ay 200 pesos. Okay? Last time, merong top 4 dahil merong voluntaryo tayong amicus na nag-donate para sa top 4 at top 5 si Sergeant Ryan. Okay? So, hopefully, manood kayo ng ating mga lectures din ng iba pa nating lecturers. Tomorrow, babalikan ni Ma'am Jinky Mazo yung kanyang mock board exam rationalization sa crime detection and investigation. Kasi nung nakaraan din, nag-live siya ng 1 to 50, medyo may aberya talaga sa internet. Kaya pag-upload, medyo choppy. Kaya napagkasunduan namin na uulitin na lang niya yung questions number 1 to 50, tapos itutuloy niya ulit yung 51 to 100. Okay? Kukumplituhin niya bukas. Okay? Then by June 25 and June 26, schedule naman ng lecture ng Ang Panday. Si Lieutenant Colonel Enrique Agtarap ang ating lecturer sa Law Enforcement Administration sa June 25 and June 26, 2 p.m. onwards. Okay? And ang ating lecturer naman sa Rationalization ng Board Exam Trial sa Law Enforcement Administration, napakahusay ng ating lecturer na yan. Ang ating lecturer ay si Sir Airport Police Officer 1, John Aldrin Mayaw. Si Sir John Aldrin Mayaw, graduated magna cum laude. Okay? Isa sa pinakamagaling kong estudyante nung matututunan sa kanya. Okay? So aside from that, si Sir John Aldrin Mayaw ay nag-yun yan sa National Rizal and History Quiz B. So sa buong Pinas. Not once, but twice. 2 beses siya nag-champion. Naganap yan sa Baguio. It was sponsored by the Order of the Knights of Rizal. Kaya pagdating sa mga memorization, pagdating sa mga pag-aaral, kahit isang bag pa na reviewers ang ibigay kay Sir Mayo, kayang-kaya niyang i-memorize, kayang-kaya niyang aralin lahat. At posible, at maaari namang i-share niya yan sa inyo sa oras na siya na ang mag-lecture sa inyo sa July 3. So July 3, 2020 ang ating rationalization. Ang time lamang ang hindi pa sure kung what time kasi syempre busy rin sila sa trabaho nila, So pero sigurado na July 3 ang kanyang schedule ng rationalization. Okay? So mga ilan na kaya tayo? Okay? So pwede na siguro tayo mag-start, So i-share lang natin mag-share lang tayo. Ilagay mo live lecture, watch live lecture. Okay. So start na tayo. Let's start with the question number 51. Okay? Babalikan natin yung number 51. The question is, all of the following are circumstances inherent in treason. All of the following are circumstances inherent in treason except A. Treachery, B. Bond, C. Abuse of superior strength, D. Evident premeditation. What is your answer, Miami Sai? The answer is, what is your answer, Miami Sai? Ang tinatanong ay except. Alin daw ang circumstances na hindi inherent in treason? Kasi all of the following are circumstances inherent in treason. Okay? Yung treachery, abuse of superior strength, and evident premeditation are circumstances inherent in treason. So kapag sinabing inherent, ibig sabihin, talagang kasama yung mga circumstances na yan sa pag-commit ng isang particular na krimen o naka-attach sa crime, kaya hindi kino-consider na itaas sa pagtaas ng penalty na ipapataw sa offenders. So ang tamang sagot, Miami Sai, is bond. Sa Spanish, ang bond ay en cuadrilla. E-N C-U-A-D-R-I-L-L-A. En cuadrilla. So kung may higit sa 3, so at least ibig sabihin at least 4 armed persons or 4 armed men ang kasali sa paggawa ng krimen directly or indirectly is deemed committed by a bond. Bond is an aggravating circumstance, but bond is not inherent in treason. So the answer is letter B. Okay, let's proceed, Miami Side, to question number 52. All of the following are circumstances aggravating in treason. All of the following are circumstances aggravating in treason, except. So ang hinahanap ay maliban sa ano? A. Ignominy. B. Abuse of superior strength. C. Cruelty. D. Amount or degree of aid. Circumstances na aggravating sa treason, ignominy, cruelty, amount or degree of aid. Okay? So, pero mayroon pang ikaapat. Ang ikaapat na circumstance na aggravating sa treason ay gravity of separate distinct acts of treason. So, wala sa choices yung pang-apat. So, ibig sabihin, among the choices, ang di kasama rather, ay abuse of superior strength. So, ang sagot ay letter B. Dahil ang abuse of superior strength ay inherent sa treason. Okay? Nakuha. So, the answer is letter B sa number 52. So, let's proceed with question number 53. Okay. The government is at war with China. The Philippine government did not prohibit correspondence to China. Mario has a pen pal in China named Fuqian, and out of love sent her a letter saying, I love you, I miss you, chup chup mama. Is Mario criminally liable? Again, the government is at war with China. The Philippine government did not prohibit correspondence to China. Mario has a pen pal in China named Fuqian, and out of love sent her a letter saying, I love you, I miss you, chup chup mama. Is Mario criminally liable? A. Yes, for correspondence with hostile country. B. Yes, for violation of neutrality. C. Yes, for inciting to war or giving motives for reprisals. Or D. No, as there was no crime committed. Okay. So correspondence with hostile country ay nakukomit in time of war. So ang correspondence with hostile country, tatandaan, may amisay, is a war crime in which the Philippines is involved. Okay? Correspondence with hostile country ay nakukomit in time of war in which the Philippines is involved. Tandaan yan, may amisay. It cannot be committed in time of peace. At ang offender ay gumawa ng sulat papunta o patungo sa kalabang bansa o teritoryo na okupado ng kalabang bansa ng Pilipinas. Kung ang pagpapadala ng sulat ay ipinagbabawal ng pamahalaan, kahit na ang sulat mo contains innocent matters, kahit love letter lang ang laman, liable ka sa correspondence with hostile country. Pero kung walang prohibition, walang prohibition ang government at love letter lang ang laman tulad sa facts, no criminal liability. So the answer is B. So no, as there was no crime committed. Kasi walang prohibition by the government, at ikalawa, yung kanyang love letter contains innocent matters. Ang laman lang ang sulat niya, I love you, I miss you, chup chup mama. Okay? Subalit, kung ang sulat mo is carried on in ciphers or conventional signs, ibig sabihin, ang sulat mo ay hindi normal na panulat o alphabet o may ginagamit kang ibang uri ng pagsulat na maaaring ikaw lamang at yung sinulatan mo ang nakakaintindi, kahit walang prohibition ng government ang correspondence, liable ka pa rin. So, naintindihan nyo ang pagkakaiba. O halimbawa, kahit walang prohibition ng government. Walang prohibition pero ang sumo ay naglalaman ng mga impormasyon tungkol sa seguridad ng bansa na makakatulong sa kalabang bansa, liable ka for correspondence with hostile country. So, naintindihan, Miami side, okay? Ang correspondence with hostile country. So, let's proceed with question number 54. Mutiny is akin to what crime? Mutiny is akin to what crime? A. Kudeta. B. Sedition. C. Rebellion. D. Direct assault. What is your answer, Miami Zai? So, yung sagot nyo, pwede nyo i-comment sa comment section, okay? Para malaman natin kung naiintindihan nyo. Ang pag-commit ng mutiny ay halos katulad ng crime na sedition. So, ang answer ay sedition, letter B. Ang kasong sedition ay pag-aaklas at panggugulo sa pamamagitan ng pamumwersa, pananakot, o iba pang illegal na pamamaraan upang makamit ang layunin ng mga offenders. Ang offenders sa sedition ay maaaring pribadong individual o public officers o employees. Ang mga layunin ng mga offenders sa sedition ay alinman sa mga sumusunod. Number 1, pigilan ang pagpasa ng isang partikular na batas or ang pagpigil sa magaganap na halalan. Ikalawa, pigilan ang pamahalaan at mga nanunungkulan na gawin nila ang kanilang mga sinumpaang tungkulin o pigilan ang pagpapatupad ng anumang ipinalabas na administrative order or kautusan. Ikatlo, isang dahilan ng panggugulo ay upang makapaghiganti laban sa public officer o empleyado o paghiganti sa mga pribadong individual o maging isang particular na grupo o class of persons upang makamtan ang kanilang political at panglipunang layunin. Halimbawa, ito yung pinaka-trending topics ngayon sa mga riders. Halimbawa, tutol yung mga riders na ipatupad ang doble plaka law. Okay? Maraming nagrereklamo sa batas na to, lalo na yung mga apektadong riders. So nagkaroon sila ng motorcade at rally. Maaari nila itong gawin bilang pagkilala sa kanilang karapatan o constitutional rights on freedom of speech and freedom of expression. Subalit Miami side, sa oras na lumikha na sila ng kaguluhan sa ginaganap na motorcade o rally upang tutulan at pigilan ang pagpapatupad ng mga otoridad sa doble plaka law, maaari na silang makasuhan ng sedition. Okay? Ikaapat, halimbawa, paano pa nakukumit ang sedition? Pagkuha o pagbawi ng anumang ari-arian ng isang tao, munisipalidad, probinsya, o maging ang pambansang pamahalaan ng Pilipinas upang makamtan ang kanilang political at panlipunang mga layunin. In short, ang sedition ay pagtutol o pagprotesta ng mga mamamayan sa pamamaraang illegal o panggugulo ng at least 4 na tao para pumasok sa term na subsorb ng sedition. Ulitin natin, kapag common crimes, hindi sa mga offenders bukod sa crime na gamit ng unlicensed firearm. Dahil ang use of licensed firearm is absorbed by sedition. Tandaan yan, Miami Sai, okay? Sa kudeta, ang offender ay mga may posibleng laban sa pamahalaan sa pamamagitan ng violence, intimidation, threat, strategy or stealth o patago. Ang inaatake ay kampo ng militar, communication networks o public utilities tulad halimbawa ng Meralco, PLDT, GMA, ABS-CBN, Manila Water, Maynilad. At ang purpose ng offender ay mabawasan ang kapangyarihan ng Estado. Ito ay maaaring makamit kung meron man o walang partisipasyon ng mga civilian. So ang keyword sa kudita may homicide is it is committed by swift attack. Okay? Pag itong definition, it is committed by swift attack, kudita ang sagot. Okay? Rebellion. Ang object naman ng mga offenders sa krimen na rebellion ay patalsikin ang kasalukuyang gobyerno. Crime of the masses, o ibig sabihin, pangmaramihang tao ang involved dito upang maisulong ang kanilang mga political agenda laban sa gobyerno ng Pilipinas. Sa board exam, ang keyword na tatandaan ay rise publicly and taking up arms against the government. Okay, tandaan yan, Miami side. Pag-aaklas sa pamamagitan ng dahas laban sa pamahalaan. Isa rin sa objective din ng offenders sa rebellion ay ihiwalay ang isang bahagi ng Pilipinas. Halimbawa, ihiwalay ang Mindanao sa Pilipinas sa pamamagitan ng ginagawa nilang pag-aaklas o naman. Kaya sila nag-aaklas ay upang maalisan ng kapangyarihan ang Pangulo o Kongreso. Hindi kasama ang judiciary. Tandaan nyo hindi kasama dyan ang judiciary. Dahil kung ang purpose ng offender ay alisan ng kapangyarihan ang Supreme Court, hindi siya papasok sa rebellion, pero papasok naman siya sa sedition. Okay? Tandaan yan, Miami saya. Offender sa rebellion ay kahit sinong kasali sa pag-aaklas laban sa gobyerno ng Pilipinas. Tandaan din, Miami say, napaka-importante nito, walang complex crime na rebellion with murder o iba pang common crimes. Ibig sabihin, sa pag-commit ng rebellion, nagkataon na may mga namatay, may sinunog, o iba pang krimen na ginawa yung mga offenders, provided nangyari yon in furtherance of rebellion, kalimutan lahat ang krimen na nangyari maliban sa rebellion dahil rebellion lamang ang krimen. All other common crimes committed in furtherance of rebellion are absorbed by rebellion. Okay? Tandaang mabuti absorb ng rebellion ang lahat ng common crimes, provided they are committed in furtherance of rebellion. Okay? So, ang pag-atake naman sa person in authority at agent of a person in authority ay direct assault. So, let's take an example. Halimbawa, dahil hindi ka nabigyan ng ayuda, inatake mo si Mayor Joy habang namimigay siya ng relief goods o in the performance siya ng kanyang duties. Nakita ito ng traffic enforcer. Inawat ka ng traffic enforcer at nagalit ka sa traffic enforcer, kaya inatake mo din si traffic enforcer. So, ang pag-atake kay Mayor Joy, who is a person in authority, is direct assault. Ang pag-atake kay traffic enforcer, who is an agent of a person in authority, is direct assault din. Okay? Attack to a person in authority, attack to an agent of a person in authority, direct assault. Tandaan niya, Miami side. Another example. Nagbibigay ng grade si teacher A. Bagsak si student B, kaya nagalit siya kay teacher A at inatake ni student B si teacher A. So to the rescue ang favorite student na si student C. Kaya nagalit naman si student B, inatake niya yung classmate niya na si student C. Okay? So anong crimes committed by student B? Kay teacher, who is a person in authority, is direct assault. Okay? Kay student B, student lang siya. Pero, dahil to the rescue siya sa person in authority, nagle-level up. O kumbaga, for purposes of direct assault, ay napopromote si student B sa level ng agent of a person in authority. Kaya, direct assault din kay student C. Okay? So kasi naging agent of a person in authority, C. Okay? Student B, ang umatak ay si ni traffic enforcer A, pinara ni traffic enforcer A, si driver B. At ito ni tambay C. Ano ang crime committed by driver B? Kay traffic enforcer A na agent of a person in pero kay tambay C. Tanda nito, mayaming sayang, kay a person in authority. Kaya in this case, B sa ginawa niyang pag-atake kay tambay C. Okay? Naintindihan, mayaming say. Tandaan mabuti ang direct alarm. Okay? So next question tayo. MV Victoria is a Philippine vessel located in the high seas. B, C, and D is committed by A, B, C, and D. MV Victoria is a Philippine vessel located in the high seas. Passengers A, B, C, and D took some personal belongings of its complements and other passengers. What crime was committed by A, B, C, and D? A, piracy under Article 122 of the Arbitrary. Piracy or PD 532 na piracy in Philippine waters by strangers to the vessel. When done in high seas by strangers to the vessel, when done to, okay? When done in Philippine waters by passengers or members, PD 532. When done in high seas by passengers or members, okay? When done in high seas by passengers or members, tulad sa facts sa question number 55, it is robbery in an uninhabited place. So the answer is letter C. Ulitin natin, may amisay, ang rules in piracy. When done in Philippine waters by strangers to the vessel, ang gagamitin mo ay piracy under Article 122. When done in high seas by strangers to the vessel, ang gagamitin mo ay piracy under Article 122. When Philippine waters by passengers or members, ang gagamitin mo ay piracy under PD 532. High seas by passengers or members, ang gagamitin hindi 122, hindi 532 kasi ito na ay robbery in an uninhabited place. Okay? Okay, next question. Question number 56. Nolly was arrested by police officers while standing in a sidewalk. He was said to have numerous cases of cell phone snatching in the area. When in the station, the investigating officer was not present. The police officers told Nolly to come back, for if not, he will be killed when they see him. Nolly from time to time comes back to the station, but the investigating officer was still on leave. Question, are the police officers liable? Ulitin natin. Nolly was arrested by police officers while standing in a sidewalk. He was said to have numerous cases of cell phone snatching in the area. When in the station, the investigating officer was not present. The police officers told Nolly to come back, for if not, he will be killed when they see him. Nolly from time to time comes back to the station, but the investigating officer was still on leave. Are the police officers liable? A, yes, for arbitrary detention. B, yes, for grave coercion. C, yes, for grave threats. D, no, because there was no crime committed. What is your answer? May amisay? So, let's explain. Ang mga pulis sa facts ay hindi liable sa arbitrary detention kasi wala namang actual restraint kay Nolly. But The fact that Nolly always goes back was due to the threats made liable for grave threats. Okay? If the threat amounts to a crime, ang crime ay grave threats. So, ang answer sa number 56 ay C. Yes, for grave threats. Okay, let's proceed with question number 57. Karugtong ng 56, yung facts. If in the same problem, if under investigation, Nolly was forced to confess, he would not want to confess. After 2 hours, the police officers gave up and released him. Are the police officers liable? Again, if in the same problem, if under investigation, Nolly was forced to confess after officers gave up and released him. Are the police officers liable? A. Yes, for arbitrary detention. B. Yes, for grave coercion. C. Yes, for grave threats. D. No, because there was no crime committed. What is your answer, Miami Sai? What is your answer? So explain natin. Dahil wala pa rin namang actual restraint, walang actual restraint sa facts kay Nolly, hindi pa rin liable ang mga polis sa arbitrary detention. Since Nolly was compelled to do something against his will, thus the police is liable for grave coercion. Okay? So ang answer sa 57 ay B, yes, for grave coercion. Okay? Question number 58. Okay, next question. Question number 58. Mayor Christian was officiating a kasalang bayan. Richard went at the back of Mayor Christian and shot him at the back using a firearm. Mayor Christian died. What crime was committed by Richard? Again, Mayor Christian was officiating a kasalang bayan. Richard went at the back of Mayor Christian and shot him at the back using a firearm. Mayor Christian died. What crime was committed by Richard? A. Direct assault. B. Direct assault with murder. C. Qualified direct assault with murder. D. Qualified direct. Explain muna natin. Si Mayor Christian, special duty kasi kahit ano pa ang motibo ni Richard, there is direct assault. Okay? Namatay si Mayor Christian by treachery. Ano yung qualifying circumstance? Mayroong treachery because he was shot at the back using a firearm. Thus, the crime is direct assault with murder. Subalit, take note, my amisay, there was use of a firearm or weapon. Again, there was use of a firearm or weapon. Thus, the crime. Letter C. Direct assault with murder. Tama ba ka, may amisay? Okay? So, what is qualified direct assault? It is qualified when the assault is committed with a weapon. That's number 1. And number 2, the offender is a public officer or employee. And number 3, the offender lays hands upon a person in authority. Nagiging qualified direct assault in these 3 instances. Okay? So let's continue, Miami Sai, with question number 59. Gardo had an intent to kill Gerald. However, when Gardo discharged the firearm, Gerald saw it and was able to evade the bullet. What crime was committed? Again, Gardo had an intent to kill Gerald. However, when Gardo discharged the firearm, Gerald saw it and was able to evade the bullet. What crime was committed? A. Alarms and scandal. B. Illegal discharge of firearm. C. Attempted homicide. D. Attempted murder. Anong sagot nyo, Miami-san? Anong sagot nyo? Ang tamang sagot ay attempted homicide. So, even if Gerald was not hit, the fact that Gardo discharged the firearm against Gerald with intent to kill, mayroong overt act directly connected to homicide. Kaya, ang crime is attempted homicide, letter C. Okay? Next question, question number 60. Possession of dangerous drugs during parties, social gatherings, or meetings must be in the proximate company of at least how many persons? Possession of dangerous drugs during parties, social gatherings, or meetings must be in the proximate company of at least how many persons? A. 1. B. 2. C. 3. D. 4. So, ang tinatanong dito sa 60 ay ito yung pot session. Pot session, para maging liable kayo sa pot session during party, social gatherings, or meetings. Para maging liable sa pot session, kinakailangan may kasama kang at least 2 tao. So, minimum sa pot session ay 3. 3 tao under Section 13 of RA 9165. So the answer is letter C. Tama ba kayo? Miami-san. Question number 61. A drug syndicate is A. Any organized group of 2 or more persons forming or joining together with the intention of committing any offense prescribed under RA 9165. B. Any organized group of 3 or more persons forming or joining together with the intention of committing any offense prescribed under RA 9165. D. Any organized group of 5 or more persons forming or joining together with the intention of committing any offense prescribed under RA 9165. So sa A, organized group of 2 or more persons. Sa B, organized group of 3 or more persons. Sa C, organized group of 4 or more persons. Sa D, organized group of 5 or more persons. Okay, para matawag drug syndicate? A drug syndicate is any organized group of 2 or more persons forming or joining together with the intention of committing any offense prescribed under RA 9165. So, ang answer, Miami-san, is letter A. Okay? Let's continue with question number 62. Which of the following statements is correct? Alin daw ang tama? A. Trafficking is deemed committed by a syndicate if carried out by a group of 2 or more persons conspiring or confederating with one another. B. Trafficking is deemed committed by a syndicate if carried out by a group of 3 or more persons conspiring or confederating with one another. C. Trafficking is deemed committed by a syndicate if carried out by a group of 4 or more persons conspiring or confederating with one another. D. Trafficking is deemed committed by a syndicate if carried out by a group of 5 or more persons conspiring or confederating with one another. Okay? So, ito ay Anti-Trafficking in Persons Act of 2003. Trafficking is deemed committed by a syndicate if carried out by a group of 3 or more persons conspiring or confederating with one another. Kanina dun sa drugs, 2 lang. Dito sa trafficking, 3. So, ang answer is letter B. Okay? Next question, question number 63. Julius has a pending case for the crime of murder before the office of the prosecutor. Office of the prosecutor Jonas. He offered the amount of 1 million pesos to prosecutor Jonas, and in return, the latter dismissed his case despite finding of probable cause. What crime was committed by prosecutor Jonas? Again, Julius has a pending case for the crime of murder before the office of prosecutor Jonas. He offered the amount of 1 million pesos to prosecutor Jonas, and in return, the latter dismissed his case despite finding of probable cause. What crime was committed by prosecutor Jonas? A. Prevarication or negligence or tolerance in the prosecution of offenses. B. Direct bribery. Letter C. Qualified bribery. Letter D. Corruption of public official. Okay? So, anong sagot nyo? May homicide? Comment nyo yung sagot nyo. So, nabanggit na natin sa part 1 and part 2 ng ating ratio, kapag indirect bribery, tatanggap ka ng suhol, pero walang kapalit. Basta binigyan ka lang dahil sa posisyon mo. Kapag direct bribery naman, kapag may kapalit na pabor o may gagawing pabor si public official, kapalit ng suhol o regalo sa kanya. So direct bribery. Halimbawa, judge, binigyan ng 1 million para i-dismiss ang kasong homicide ng akusado. Okay? So direct bribery kasi may kapalit. Pag walang kapalit, indirect bribery. Okay? Pag qualified bribery naman, katulad ito ng direct bribery. Pero kapag ang kaso ng nanuhol sa iyo ay may parusa na reclusion perpetua o mas mataas pa, tulad halimbawa ng Parricide, kapalit ng suhol halimbawa, ipapawalang sala mo siya. Hindi lamang direct bribery ang kaso, nagiging qualified bribery. Okay? Kapag yung kaso ng taong nanuhol ay reclusion perpetua ang parusa at mas mataas pa, qualified bribery. Okay? So kung ang krimen ng taong nagbigay ng suhol o regalo sa public official ay may parusa na mas mababa sa reclusion perpetua, kapalit ng suhol, hindi i-dismiss ang kaso niya. Tulad halimbawa, si fiscal, public officer, siya ay liable under Article 208, prevarication, negligence or tolerance in the prosecution of offenses. Okay? So, corruption of public officials, kaso ng nagbigay o nanuhol. Okay? Yung nanuhol, ang kaso, corruption of public official. Yung sinuhulan, bribery. Okay, question number 64. It is a law which grants immunity from prosecution to givers of bribes and other gifts and to their accomplices in bribery and other graft cases against public officers who voluntarily give information and willingly testify against a public official or employee. It is a law which grants immunity from prosecution to givers of bribes and other gifts and to their accomplices in bribery and other graft cases against public officers who voluntarily give information and willingly testify against a public official or employee. A. Presidential Decree number 748. B. Presidential Decree number 749. C. Presidential Decree number 750. Or D. Presidential Decree number 751. So nabanggit na natin ito sa either sa unang ratio or ikalawang ratio natin. Okay? So, yung immunity from criminal prosecution ng mga nagbibigay ng suhol, kung voluntary silang nagbibigay ng impormasyon tungkol sa mga public officials na tumanggap ng suhol. Okay? So, PD 749. Okay, next. Question number 65. All of the following are classified as crimes mala inse. Lahat daw ay mala inse maliban sa ano? Except A. Malversation of public funds or property. B. Illegal use of public funds or property. or technical malversation. C. Illegal exaction. D. Maltreatment of prisoners. Ano-ano ba ang pagkakaiba ng mala inse at mala prohibita? Pag mala inse, plural. Ang singular form, malum inse. Yung mala prohibita, plural din. Ang singular form, malum prohibitum. Okay? Ang mala inse ay inherently wrong. Ibig sabihin, mula simula, ang mga ito ay masasamang acts na talaga. Ang mala prohibita naman is not inherently wrong or are not inherently wrong. Nagiging masama lamang dahil may bagong batas na nag-penalize na sa particular acts na yon. Okay? Ang mala inse, generally, ay punished ng revised penal code. So, kapag violation ng RPC, mala inse. Okay? That is the general rule. Exception. Ano exception sa crimes mala inse? Sa crimes mala inse, merong special penal law na hindi siya malum prohibitum, bagos malum inse siya. Republic Act number 7080 o ang tinatawag natin na plunder law. Though punished by special penal law, hindi ito malum prohibitum, bagkus malum inse ito kasi yung plunder o pandarambong ay inherently evil, inherently wrong. Okay? Naintindihan? So, ikalawang distinction, mala prohibita. Generally, kapag mala prohibita, punished by special penal laws. May exception. Ito na yon. Letter B. Technical malversation or illegal use of public funds or property under Article 220 ng RPC. Bagamat violation siya ng RPC, hindi siya malum inse. Siya ay malum prohibitum. Kasi hindi siya inherently evil, kaya malum prohibitum. So ang sagot, technical malversation or illegal use of public funds or property. Okay? Paano ba nakukomit ang technical malversation o illegal use of public funds or property? Let's take an example. May pondong inilaan ang batas sa Department of Health para sa testing kits dahil plano ng pamahalaan na magkaroon ng mass testing upang mas mapabilis ang pag-trace sa mga taong infected ng COVID-19 at agad mahiwalay at may paggamot sila. Okay, mahiwalay sa mga mas nakakaraming tao para may paggamot. Subalit, ang ginawa ng DOH Secretary, halimbawa lang to ay hindi pinambili ng test kits, bagkus ay pinambili niya ng personal protective equipments o PPE, hindi test na gagamitin sa mass testing. In this case, yung pera ng gobyerno ay inilaan para sa test kits pero ipinambili ng PPEs. Hindi kinupit o ginamit ang pondo ng pamahalaan para sa pansariling kapakanan ng DOH Secretary. Ginamit pa rin para sa public purpose. Subalit, ipinagbabawal ng batas ang paglipat sa pondo ng pamahalaan na inilalaan ng batas sa isang particular na bagay o particular na gastusin. Ang maaaring maging kaso ay illegal use of public funds or property na tawag na technical malversation. Ulitin natin, though it is punished under the revised penal code, hindi ito malum inse. As an exception to the rule, ito ay malum prohibitum. Okay? Halimbawa naman ng malversation of public funds or property. May pondong inilaan ng batas sa Department of Health para sa testing kits dahil plano ng pamahalaan na magkaroon ng mass testing. Ganun din. Para mas mapabilis ang pag-trace ng mga taong infected ng COVID-19 at maihiwalay at may paggamot agad sila. Okay? Subalit, ang ginawa ng DOH Secretary, kunyari lang to ay hindi pinambili ng test kits, bagkus ay pinambili niya ng kondo, mga sasakyan, bahay at lupa at iba pa para sa pansariling kapakanan. So, ang crime committed ay malversation of public funds or property. Kapag ang pondo ng gobyerno ay ginamit sa paniling kapakanan ng public official o halimbawa, pinayagan niya ang ibang tao na gamitin ang pondo ng gobyerno. Okay? So let's continue with the distinction between mala inse and mala prohibita. Sa mala inse, good faith ay valid defense maliban na lang kung tinatawag na commit na crime ay by fault o culpa. Samantala, sa mala prohibita, good faith is not a defense. Halimbawa, pumunta ka sa NAIA, may shabu ka pala sa bag, pero di mo alam na may shabu ka palang nakalagay doon. Liable ka pa rin under RA 9165 kasi nga, yung RA 9165 is malum prohibitum. Okay? O act na pinaparusahan ng paglabag ng special penal law. Sa special penal law, good faith is not a valid defense. Okay? Tandaan niyang mabuti. Another distinction. Sa mala inse, intent is material. Kailangan may criminal intent para maging liable ang offender. Kapag walang intent, hindi liable ang offender sa mala inse. 3 elements ng intentional felonies. Diba? Tatandaan nyo, we have intelligence, freedom, at intent. Kapag wala ang isa sa tatlong ito, hindi liable ang offender. Okay? Sa mala prohibita, ang criminal intent ay hindi mahalaga. Okay? Another distinction. Sa mala inse, may degree of accomplishment. Ano na yung degree of accomplishment? Degrees of accomplishment. We have attempted, frustrated, consummated. Sa mala inse. Sa mala prohibita, walang degree of accomplishment. Laging consummated. Sa mala inse, inia-apply ang mitigating at aggravating circumstances sa pagpataw ng penalty. Sa mala prohibita, hindi ina-apply ang mitigating at aggravating circumstances. Maliban na lamang kung ang special law ay ginamit ang mga penalties ng revised penal code. In that case, pwede nang i-apply yung mitigating at aggravating. But as a general rule, pwede lamang siya sa mala inse. Okay? Another distinction. Sa mala inse, kung maraming offenders, tinitingnan yung degree ng participation ng offender. Kung ikaw ba ay principal, accomplice, o accessory. Samantalang sa mala prohibita, ang lahat ay principals. Okay? Another, sa mala inse, ang penalties dito ay pwedeng ma-divide into degrees. Okay? Pwedeng ma-divide into degrees. Yung reclusion perpetua, reclusion temporal, reclusion mayor, etc. At may periods pa. Okay? Yung may minimum, medium, maximum. Sa mala prohibita, walang division of penalties. Okay? So, malinaw ang pagkakaiba ng mala inse at mala prohibita. Ano naman yung illegal exaction? Ang illegal exaction ay isang halimbawa ng paglabag sa Article 213 ng Revised Penal Code. Frauds against the treasury and similar offenses. Ang illegal exaction ay hindi pagbibigay ng resibo. Halimbawa, nagbayad ka sa LTO, pero yung cashier ng LTO hindi nag-issue ng resibo sa mga nakokolekta niya, ang tawag doon ay illegal exaction. Maltreatment of prisoners, ito yung pagpapahirap, pagpaparusa sa mga taong nakakulong ng public officers na may custody sa prisoners. Okay? Naintindihan, may homicide? So let's continue with question number 66. Question number 66. Which of the following cases of parricide are not penalized by reclusion perpetua to death? A. Parricide through negligence. B. Parricide by mistake. C. Parricide under exceptional circumstances. Or D. All of them. Ang tamang sagot ay all of them. Parricide through negligence, parricide by mistake, parricide under exceptional circumstances, hindi yan pinaparusahan ng reclusion perpetua to death. Parricide through reckless imprudence, halimbawa, nagagawa ng baril si tatay at anak without intent to kill anyone. Nabit ang gatilyo ng baril at tinamaan si nanay na papalapit sa kanila. Ito ang halimbawa ng parricide through reckless imprudence. Okay? Ano naman yung parricide by mistake? Halimbawa, si A gusto niyang patayin si B na isang stranger. Kaya isang gabi, inabangan niya sa isang kanto na madilim si B, but by mistake, ang nabaril niya at ang dumaan pala doon ay hindi si B, bagkus si C na tatay ni A. Si A ay guilty sa parricide. In this case, Article 49 ang i-apply. Ito yung tinatawag na i-discuss na natin last time sa Article 4 ng RPC na error in personae. Sa error in personae, Article 49 of the RPC ang ini-apply. The penalty imposable is not the penalty for parricide na krimen na nakumit ni A. Bagkus ay penalty ng homicide na krimen na intensyon na makumit ni A. So ang tamang penalty ay reclusion temporal in its maximum period. Okay? Ano naman yung parricide under exceptional circumstances? Ito yung death under exceptional circumstances. Nahuli ng asawang lalaki na nakikipagtalik ang kanyang asawa sa ibang lalaki. Napatay niya si wife. So that is parricide under exceptional circumstances. Hindi parusa sa parricide ang parusa, kundi dischero lamang ang ipapataw. Okay? So, matatandaan nyo yung death under exceptional circumstances din yan. Okay? So, ang involved ay yung husband to wife, may relationship, kaya parricide under exceptional circumstances. Okay? Next, question number 67. Husband Polo arrived home and dinner has not been cooked. Husband Polo got mad and slapped his wife that Dina, and latter happened to be pregnant and hit the table and floor. Dina and the fetus died. What crime was committed? A. Parricide. B. Parricide in unintentional abortion. C. Parricide with unintentional abortion. D. Parricide and intentional abortion. Ano sagot nyo, Miami side? What's your answer? Na-discuss na natin ang parricide sa naunang rasyo natin. So, balikan nyo yung discussion sa part 1 at part 2 para mas maintindihan nyo. No? So, ang tamang sagot dito sa tanong na ito sa number 67 ay parricide with unintentional abortion. Okay? Parricide with unintentional abortion, letter C. You have to complex since it resulted from a single act. Okay? So, yung wife, tapos na-abort yung baby, unintentional abortion. So, parricide with unintentional abortion. Iko-complex mo since it resulted from a single act. Letter C. Okay? So let's continue. Magkadumang number 68 at 67. Suppose in the same problem, only the fetus survived. Okay? Namatay pa rin si wife. What crime was committed? Nabuhay si fetus. A. Parricide. B. Parricide and frustrated unintentional abortion. C. Parricide with frustrated unintentional abortion. Or D. Parricide with unintentional abortion. Anong sagot niyo, Parricide, sa number 68? Ang tamang sagot sa follow-up question na ito ay parricide only, letter A. As to the fetus, it can't be frustrated unintentional abortion because there is no such crime. Walang frustrated unintentional abortion. Kaya ang crime is parricide only sa 68. Okay? Next question, question number 69. Question number 69. Father Bingo, 80 years of age, and son, Aldrin, had an argument. Aldrin boxed his father, resulting to the latter's becoming ill for more than 30 days. What crime was committed? Again, Father Bingo, 80 years of age, and son Aldrin had an argument. Aldrin boxed his father, resulting to the latter's becoming ill for more than 30 days. What crime was committed? A. Serious physical injury. B. Qualified serious physical injury. C. Parricide. D. Less serious physical injury. Anong sagot nyo? Miami side. Comment your answer. So in this case, ang tamang sagot ay qualified serious physical injury. Letter B. Letter B. So offended party is any of those mentioned in the crime of parricide. Kung ang relationship ng offender at victim ay pasok sa relationship na nabanggit sa parricide, like in this case, ang biktima ay si tatay at ang offender ay anak, naging qualified serious physical injury. Okay? Again, another, nagiging qualified serious physical injury if any of the circumstances that will qualify the crime of murder is present. So, dalawang pagkakataon. Okay? Nagiging qualified serious physical injury. Una, the offended party is any of those mentioned in crime of parricide. Second, any of the circumstances that will qualify the crime of murder is present. Okay? Letter B. So next question, question number 70. Nerissa, 11 years old and 11:35.
Machine.
Dito ka tumingin sa
67.
60 ano tayo? Stop pala, mayam sa'yo, no? Kanina pa pala eh.
Okay.
Okay. Kanina pa pala ako salita ng salita. Nawala na naman. Internet talaga. Okay. Balikan natin, Miami Side. Balik tayo sa number 67. Dami ko na palang na-discuss na questions. Okay. Number 67 tayo. Husband Polo arrived home and dinner has not been cooked. Husband Polo got mad and slapped his wife, Dina, and the latter happened to be pregnant and hit the table and floor. Dina and the fetus died. What crime was committed? A. Parricide. B. Parricide and unintentional abortion. C. Parricide with unintentional abortion. D. Parricide and intentional abortion. Okay? So, sabi ko kanina, na-discuss na natin yung parricide sa part 1 at part 2 ng ating ratio. Okay? Balikan nyo mabuti yun kasi paborito ang parricide sa board exam. So, ang tamang sagot dito sa tanong sa question number 67 ay parricide with unintentional abortion. Parricide kasi namatay yung wife and with unintentional abortion sa pagkakalaglag ng baby. So, hindi siya separate crimes. Iko-complex mo, complex crime. Since it resulted from a single act. Single act lamang ni husband Polo. A, ay connected sa 67. Suppose in the same problem, 68. Suppose in the same problem, only the fetus survived. What crime was committed? A. Parricide. B. Parricide and frustrated unintentional abortion. C. Parricide with frustrated unintentional. Unintentional yan abortion. Ang tamang sagot sa parricide only. Parricide only may homicide. Ang tamang sagot ay parricide only, letter A, kasi as abortion, hindi pwedeng frustrated kasi hindi namatay, no? Hindi tuluyang namatay kasi nabuhay. Hindi pwedeng frustrated unintentional abortion because there is no such crime. That's why parricide only. Okay? Question number 69. Father Bingo, 80 years of age, and son Aldrin had an argument. Aldrin bashed his father, resulting to the latter's becoming ill for more than 30 days. What was committed? Again, Father Bingo, 80 years of age, and son Aldrin had an argument. Aldrin bashed his father, resulting to the latter's becoming ill for more than 30 days. A. Serious physical injury. B. Qualified serious physical injury. C. Parricide. D. Less serious physical injury. Anong sagot nyo? May homicide? Ang tamang sagot ay qualified serious physical injury. Okay? Kailan magiging qualified serious physical injury? Number 1, offended party, yung biktima, is any of those mentioned in the crime of parricide. Kung ang relationship ng offender at victim ay pasok sa relationship na nabanggit sa parricide, in this case, ang biktima ay si tatay at ang offender ay anak, nagiging qualified serious physical injury. Another, kailan ulit magiging qualified serious physical injury? Kapag any of the circumstances that will qualify the crime of murder is present, qualified serious physical injury. Ulitin natin. Kailan naging qualified serious physical injury? Number 1, offended party is any of those mentioned in the crime of parricide. Okay? Another, any of the circumstances that will qualify the crime of murder is... So let's proceed with question number 70. Nerissa, 11 abandoned wife without the benefit of marriage. Kevin had carnal knowledge of Nerissa 5, if any. Again, Nerissa 11 years old and wife ay mahina simula nung June. Bumili ako ng problema talaga to pag online class, no? Mahina ang signal. Okay, ulit natin. Nerissa 11:35 were cohabiting as husband and wife without the benefit of marriage. Lynn had carnal knowledge of Nerissa 5 times. What was the crime committed, if any? A. 5 counts of rape. B. 5 counts of statutory rape. C. 1 count of statutory rape only. D. No crime since they were cohabiting as husband and wife. Ang tamang sagot ay counts of statutory rape. Child under 12 years old cannot be rape pa rin, okay? 1 act of carnal knowledge is equivalent to 1 count of rape. 5 beses din yung counts ng kaso, okay? Kasi nga hindi siya continuing offense. Question number 71. Patrolman Edgar is in custody of PDL Rose. The former had carnal knowledge with the latter. What crime was committed? A. Rape. B. Qualified rape. C. Qualified seduction. D. Seduction. Ang tamang sagot dito may homicide ay qualified rape. Okay? When the victim is under the custody of the police or military authority, qualified rape. Ano pa yung mga circumstances na nagkakaroon ng qualified rape? Makinig mabuti. When the victim is below 7 years old. Pag below 12, statutory rape, that he is afflicted with HIV or AIDS. Ibig sabihin, yung offender mo, B, qualified rape. Third party, when the offender knew of the mental disability, emotional disorder, or physical handicap of the offended party, qualified rape. When the victim is below 18 years of age and the offender ay parent, ascendant, step-parent, guardian, relative within the third degree, or the common law spouse of the parent of the victim, qualified rape. When the rape is committed in full view, sabihin nakikita, when the rape is committed in full view of the spouse, parent, or relative within the third degree of consanguinity, qualified rape. And engage in legitimate religious vocation. Madre, ni-rape. So, hindi lang rape ang kaso, nagiging qualified rape. Okay? Another question number 72. Alma was going home when three drunk men, Bernard, Charlie, and Dennis, grabbed her and pulled her to a house and pinned her down and undressed her. When Bernard placed himself on top of her, iced her and stabbed her at the back, she died. What crime or crimes was or were committed? Again, Alma was going home when three drunk men, Bernard, Charlie, and Dennis, grabbed her and pulled her to a house and pinned her down and undressed her. Alma kicked Bernard and ran. They chased her and stabbed her at the back. She died. What crime or crimes was or were committed? A. Attempted rape with homicide. B. Rape with homicide. C. Homicide. D. Attempted rape and homicide. So, the intention was to rape and there was already an attempt. Okay? But on occasion thereof, Alma was killed. Thus, the crime is a special complex crime of homicide. Okay? Ulitin natin, ang intention ay rape si Alma at merong attempt to rape her. But on occasion, on attempt na i-rape siya, si Alma tumakbo. So, and later on, she was killed. So, the crime is a special complex crime of attempted rape with homicide. Letter A. Okay? Next question number 73. Ada and Bea were in the highway when the accused grabbed them and placed them in a secluded place. The accused tried to rape Ada. The accused struck her with a lead pipe and she died. Thereafter, Ada was raped and hit by the accused. Thinking that Ada died, accused left but Ada survived. What crime or crimes committed? Again, Ada and Bea were in the highway when the accused grabbed them and placed them in a secluded place. The accused tried to rape Ada. Bea became hysterical and shouted for help. The accused struck Bea with a lead pipe and she died. Thereafter, Ada was raped and hit by the accused. Thinking that Ada died, accused left but Ada survived. What crime or crimes? A. Rape with homicide. B. Rape with homicide. C. Rape and frustrated homicide for Ada and homicide for Bea. D. Rape with frustrated homicide for Ada and homicide for Bea. Ano sa mga homicide? Ang tamang sagot ay rape with homicide. Okay? Kahit magkaiba ang biktima ng ni-rape at iba ang biktima na pinatay, magkaiba, di ba? Si Ada at si Bea. Still, it is a complex crime so long as it is done by reason or on the occasion of the rape. Tandang mabuti yan, Mayamisay. Ang tamang sagot ay rape with homicide. Although magkaiba ang biktima ng rape, magkaiba ang biktima sa pinatay, still, it is a complex crime so long as it is done by reason or on occasion of the rape. Sabihin, the killing was done on the occasion or by reason of the rape. Okay? So, rape with homicide, letter B. Next question. Question number 74. Which of the following statements is correct? A. The crime of child pornography is deemed committed by a syndicate if carried out by a group of two or more persons conspiring or confederating with one another. Second, the crime of child pornography is deemed committed by a syndicate if carried out by a group of 3 or more persons conspiring or confederating with one another. C. The crime of child pornography is deemed committed by a syndicate if carried out by a group of 4. Mali yung typo error. 4 yan. 4 or more persons conspiring or confederating with one another. Hindi pala na-edit yung kana-copy-paste lang. Okay, sa letter D, 5 yan. So, 2, 3, 4, 5. But the correct answer is, obviously, 3. So, B ang tamang sagot. Okay? So, the crime of child pornography is deemed committed syndicate if carried out by a group of 3 or more persons conspiring or confederating with one another. Were committed. A. Forcible abduction and murder. C. Forcible abduction with murder. D. Homicide. Ang tamang sagot, anong sagot niya? Miami Sai. Ang tamang sagot ay murder. The intent to kill the woman. So, the intent was to kill Elsa. And the abduction was merely incidental. And therefore, it will not fall under kidnapping. Hindi na kidnapping, no? Kasi merely incidental yung pag-abduct. Ang qualifying circumstance dito ay cruelty due to stabbing of the victim 15 times. Kasi may 15 stab wounds. Okay? So, letter B. Next question, 26. Aljur abducted the child of Belen and Sencio. Aljur made a ransom note. Before Aljur could give the ransom note, to escape, Aljur got Bea and he died. What crime was committed? Again, Aljur abducted Bella, the child of Belen and Sencio. Aljur made a ransom note. Before Aljur could give Bea and he died. What crime was committed? A. Kidnapping and for ransom with homicide. B. Kidnapping and serious illegal homicide. Letter A. Okay, regardless of whether the killing was purposely sought, murder or homicide can no longer be complexed under Article 48, nor be treated as a separate crime, but shall be punished as a special complex crime under the last paragraph of Article 267 as amended by RA number 7659. So, letter A. Next question. Yung next question ay karugtong ng 70. Ano ba na tayo? 78. Karugtong din. If in the same problem, during the exchange of gunfire, Aljur shot the NBI agent and... Ano number ba tayo? Parang nalito ako. 77 muna. Oh, 77 muna. 77. Sorry. 77. Karugtungan ng 76, 77. Okay. In the same problem, Aljur made a ransom note and sent the note to Len and Sencio. The latter called the NBI, tracked the location of Aljur, and went to hideout. There was an exchange of gunfire. Sencio was shot and he died. What will you charge the accused? So, ang nabaril dito ay yung tatay naman nung kinidnap. Okay? What will you charge the accused? A. Kidnapping and serious illegal detention for ransom and homicide. B. Kidnapping and serious illegal detention for ransom and homicide. C. Homicide. D. Kidnapping and illegal detention for ransom. Okay? So anong sagot nyo, Parricide? Kidnapping and serious illegal detention, ransom for the abduction of the child, and another separate and distinct charge of homicide para naman sa pagpatay kay Tatay Sensyo. Okay? Hindi siya pwedeng gawing special complex crime because the law says if the victim is killed or dies as a consequence of the kidnapping or detention. Okay? So dapat, para maging special complex na kidnapping and serious illegal detention for ransom with homicide, yung biktima mismo ng kidnapping ang napatay. Kapag ibang tao, like si tatay in this case, separate crime. Okay? Kidnapping and serious illegal detention for ransom and homicide. So letter B. Next question, 78. If in the same problem, during the exchange of gunfire, Aljur shot the NBI agent and died, what will you charge the accused? Karugtong pa rin yan ng 76, 77. During the exchange of gunfire, Aljur shot the NBI agent and died. What will you charge the accused? A. Kidnapping and serious illegal detention for ransom and direct assault with homicide. B. Direct assault with homicide. C. Kidnapping and serious illegal detention for ransom. And D. Homicide. Anong sagot nyo, Miami Size, sa 78? Ang tamang sagot, kidnapping and serious illegal detention for ransom against the child. Yung biktima ng kidnapping. And direct assault with homicide against the NBI agent for being shot during the performance of his official duty. Okay? Direct assault. So, direct assault with homicide, separate crimes. Okay? Ito mga amisay ang rule in killing of a third person in kidnapping. If the person killed is not the kidnapped victim, it shall be treated as a separate crime of homicide or murder. It can no longer be complex under Article 48, nor be treated as separate crimes, but shall be punished as a special complex crime under the last paragraph of Article 267 as amended by RA number 7659, an act to impose death penalty on certain heinous crimes. Okay? So next question, question number 79. It is a phenomenon in which hostage victims express sympathy towards their kidnappers or captors. A. Cri-du-chat syndrome. B. Stockholm syndrome. C. Rett syndrome. D. Klinefelter syndrome. Okay? So kalimutan yung AC at okay? Nawala ulit yung signal. Question number 79. It is a phenomenon in which hostage victims express sympathy towards their kidnappers or captors. A. Cri-du-chat syndrome. B. Stockholm syndrome. C. Rett syndrome. D. Klinefelter syndrome. So kalimutan yung A, C at D. Wala yung kinalaman sa board exam nyo. Ang tamang sagot ay Stockholm syndrome, B. Ito ay phenomenon in which hostage victims express sympathy towards their kidnappers or captors. Iba pang tawag mga amisay sa Stockholm syndrome ay capture bonding. Capture bonding. Yan yung biktima ng hostage nagkakaroon ng sympathy sa kanilang offenders, sa kidnappers or captors. Stockholm syndrome. Okay, question number 80. Kaya pa ba, Miami Sai? Attention na ha, wala talaga tayong magawa pagdating sa signal. Alan abducted Bong, his business rival, who is a public officer. Contemplating about his acts within a day, he released Bong voluntarily. What is the crime committed and what is the effect of such release on his liability? A. Slight illegal detention and voluntary release will mitigate or extenuate his criminal liability. B. Kidnapping and serious illegal detention and voluntary release will mitigate or extenuate his criminal liability. C. Slight illegal detention and no effect on voluntary release. D. Kidnapping and serious illegal detention and no effect on voluntary release. Ang tamang sagot ay kidnapping and serious illegal detention and no effect on voluntary release. Kasi kapag ang biktima may amisay ng detention ay public officer o kaya minor o kaya naman ay babae, hindi kinakailangang more than 3 days or at least 3 days ang pagkakakulong. Kahit less than, bawa, half day lang, pero public officer, babae o kaya minor ang biktima, automatic serious illegal detention. So ang tamang sagot dito ay kidnapping and serious illegal detention, walang effect yung voluntary release sa public officer. Kahit pa pinalaya niya yung biktima na public officer, hindi mababawasan ang penalty niya. Any release will not mitigate liability of the offender. Okay? Next question, question number 81. The police arrested Sherwin for violating traffic rules and placed the man behind bars and with intent to deliver him to proper authorities, but did not file any case against Sherwin. In the afternoon, he released Sherwin. What crime was committed by the police? Again, the police arrested Sherwin for violating traffic rules and placed the man behind bars and with intent to deliver him to proper authorities, but did not file any case against Sherwin. In the afternoon, he released Sherwin. What crime was committed by the police? A. Arbitrary detention. B. Unlawful arrest. C. Arbitrary detention through unlawful arrest. D. No crime since Sherwin was released by the police. Ang tamang sagot, anong sagot niyo? Miami Sai. Ang tamang sagot ay letter C. Arbitrary detention through unlawful arrest. Okay, arbitrary detention kasi his intention was to detain Sherwin. Okay, unlawful arrest was a necessary means to commit arbitrary detention. Thus, the two should be complexed. Arbitrary detention through unlawful arrest. Okay? So, letter C. Next question. Malapit tayo matapos. Question number 82. Ace was driving his vehicle carefully and lawfully. His tire ran on a stone. The stone flew and hit Camellia in the sidewalk. Is Ace liable? Ace was driving his vehicle carefully and lawfully. His tire ran on a stone. The stone flew and hit Camellia in the sidewalk. Is Ace liable? A. No. B. Yes. C. Maybe. D. It depends. What is your answer? Is he liable, Miami Sai? Ang tamang sagot ay no. He was performing a lawful act with due care when he caused an injury without intent to injure another. Accident, Miami Sai, is an exempting circumstance under Article 12, Paragraph 4 of the RPC. So, no criminal and no civil liability. General rule sa Article 12, exempting circumstances, no criminal liability but with civil liability. Exemption dito ay yung except yung accident gaya ng nasa facts. Walang criminal at walang civil liability ang offender. So ang answer is letter A. Okay, let's proceed. Miami Sai, question number 83. Kaya pa ba? 83. Melvin told Danny, if you will not give money, I will report you to the customs for your smuggled car. What crime was committed, if any? Again, Melvin told Danny, if you will not give money, I will report you to the customs for your smuggled car. What crime was committed, if any? A. Grave threats. B. Life threats. C. Other life threats. D. No crime. Ang tamang sagot ay life threats. Kung ang threat does not amount to a crime, tulad sa tanong na ito, life threats lang. Pero kung ang threat amount to a crime, tulad halimbawa, pinagbantaan ka na papatayin ka niya, ang crime is grave threats. So ang answer in this case is letter B, life threats. Next question, question number 84. Carlo knows that the house of Anthony is vacant. Dario saw that Carlo was about to enter. So Dario prevented Carlo. Dario boxed Carlo. What crime was committed? Again, Carlo knows that the house of Anthony is vacant. Dario saw that Carlo was about to enter. So Dario prevented Carlo. Dario boxed Carlo. What crime was committed? A. Grave coercion. B. Physical injuries. C. Grave coercion and physical injuries. D. No crime. Ano sagot nyo, Miami Sai? Ang tamang sagot dito ay physical injuries. The thing Dario was trying to prevent is an act prohibited by law. Para pumasok sa grave coercion, it is necessary na si Carlo, ang offended party, is not doing a lawful act. Okay? So kaya hindi grave coercion. Ang tamang sagot ay physical injuries lamang. Okay, let's proceed with question number 85. Aiko, Beth, Carla, Diane, and Ella were walking while they heard gunfires from Elmer to get the winnings of Aiko and Beth. Aiko and Beth were robbed. Carla and Diane were killed, and Ella wounded. What crime or crimes was or were committed? Again, Aiko, Beth, Carla, Diane, and Ella were walking while they heard gunfires from Elmer to get the winnings of Aiko and Beth. Aiko and Beth were robbed. Carla and Diane were killed, and Ella wounded. What crime or crimes was or were committed? A. Robbery, murder, and attempted murder. B. Robbery with homicide and attempted murder. C. Robbery with homicide. D. Robbery, homicide, and physical injuries. Ang tamang sagot ay, ang sagot niya, Miami Sai, robbery with homicide only. Okay? Robbery with homicide. The term homicide is used in its generic sense and includes any kind of killing, whether parricide or murder, or where several persons are killed, and the name of this special complex crime shall remain as robbery with homicide. Yung qualifying circumstance, halimbawa, treachery in murder, ay magiging aggravating circumstance lamang. Okay? The juridical concept of robbery with homicide does not limit the taking of life to one single victim. All the homicides or murder, ibig sabihin kahit ilan pang napatay, are emerged in the composite integrated whole that is robbery with homicide, so long as all the killings were perpetrated by reason or on occasion of the robbery. Kahit ilan pang napatay, so long as yung killing ay nangyari by reason or on occasion nung pag-commit ng robbery, ang crime ay robbery with homicide. Okay? Sa robbery with homicide, maaaring mauna yung killing o homicide bago ang robbery, or maaari din naman na nauna ang robbery bago ang killing o pagpatay. what is essential is that the offender must have intent to take personal property before the killing. Okay? So, naintindihan. Another question, question number 86. Question number 86. Arman went to the house of Larry to rob. Larry was awakened. Arman shot Larry on his way out. He saw the latter's wife, Sally, and raped her. After raping Sally and leaving the room, he saw the maid, Maria, and raped her. On his way out of the door, the driver, Bok, saw him. He was prevented by Bok, so he shot him. Here comes the gardener, Leo. He backs Leo and suffered serious physical injuries. What crime or crimes was or were committed? A. Robbery, homicide, rape, and serious physical injuries. B. Robbery with homicide. C. Robbery with homicide and rape. D. Robbery with rape and homicide. Ang tamang sagot ay robbery with homicide, letter B. The other homicides, the rapes, the serious physical injuries are all emerged in the composite and integrated whole of a special complex crime of robbery with homicide. Okay? So kahit may na-rape, may sinaktan, robbery with homicide pa rin. Okay? So, para malaman nyo sa special complex crime, kailangan para malaman nyo yung sagot, kailangan alam nyo yung rules on absorption. Yung ibig sabihin, ano yung pagkakasunod-sunod. Okay? Sa rules on absorption, ito ang hierarchy na dapat ninyong tandaan. Ang mauuna lagi, robbery with homicide. Yung mga rape, intentional mutilation, arson, serious physical injury, kalimutan yon. Robbery with homicide. Okay? Kung halimbawa, walang pinatay, pero may on the occasion of robbery, may ni-rape, merong may intentional mutilation, may arson, may physical injury. Ang ikakaso mo, robbery with rape. Kasi ang number 2, robbery with rape. Okay? Ito, ang tandaan ha. Number 1, robbery with homicide. Number 2, robbery with rape. Ang number 3 sa hierarchy, robbery with intentional mutilation. Number 4 sa hierarchy, robbery with arson. Number 5 sa hierarchy, robbery with serious physical injuries. Pang-anim lamang ang robbery with use of unnecessary violence. At yung last, yung simple robbery or plain robbery lamang. Okay? Yun ang hierarchy. Rules on absorption. Next question, question number 87. Jedrick wanted to kill Billy. So he shot Billy with treachery and killing him instantly. Jedrick was about to leave when he noted that Billy's cell phone was an expensive model, so he took it. What crime or crimes was or were committed? A. Robbery with homicide. B. Murder and theft. C. Robbery and homicide. D. Murder and robbery. Ano sagot nyo? Miami Side sa 87. Hindi ito robbery with homicide. Ang tamang sagot ay B. Murder and theft. Okay? Murder and theft. Ang tawag dito sa rule na to ay late intent to gain or afterthought doctrine. Again, ulitin natin mga amisay, ang tawag sa principle na ito ay late intent to gain or afterthought doctrine. Sabihin, ang intention niya talaga is pagpatok. So, killing by treachery, kaya murder. So, later on, na-realize na, oh, pwede pala itong cellphone niya. So, ninakaw niya theft. So, that's why separate charges of murder and theft. Okay? Naintindihan? Late intent to gain or afterthought doctrine. Question number 88. Ayon, son of Marlon, stole the money of the latter. In the process of stealing his father's money, Marlon sought the assistance of his friend Biko. So, Ayon, son of Marlon, stole the money of the latter in the process of stealing his father's money. Marlon sought the assistance of his friend Biko. Here, A. Both Ion and Vico are exempted from liability. B. Only Ion is liable while Vico is exempted from liability. C. Only Marlon is exempted but Vico is liable as an accomplice. D. Only Marlon is exempted but Vico is liable either as principal, accomplice, or accessory. So anong sagot nyo, Miami Sai? Ang tamang sagot ay letter D. Only Marlon is exempted, but Vico is liable either as principal, accomplice, or accessory. So, merong persons exempt from criminal liability under Article 332 of the Revised Penal Code. Crimes involved in the exemption are theft, tanda na, theft, swindling or estafa, and malicious mischief. Okay, tandaan yan ha, merong persons exempt from criminal liability sa theft, swindling or estafa, and malicious mischief. Who are the persons exempted? Number 1, spouses, ascendants, and descendants, or relatives by affinity in the same line. So, dito, between ascendant and descendant. Okay? So, number 2, the widowed spouse with respect to the property nung asawang namatay bago pa maipasa sa ibang tao ang property involved. Number 3, brothers and sisters and brothers-in-law and sisters-in-law if living together. Sa number 3, applicable lamang ang exemption kapag magkasama sa isang bubong o isang bahay ang brothers and sisters and brothers-in-law and sisters-in-law. And number 4, stepfather, adopted father, natural children, concubine, paramour, included as ascendants by affinity. Okay? Ano ang reason for exemption? The law recognizes the presumed co-ownership. Pinipresume ng batas, pinagpapalagay ng batas na co-ownership or co-owned nila yung property ng offender at ng offended party. Okay? Article 332 also applies to common law spouses. Exempt din yung mga mag-asawa na nagsasama pero hindi sila kasal. Okay? So they are living as common law spouses. Kasi under Article 147 and 148 ng Family Code, common law spouses are co-owners of the property. Okay? So in this case, walang criminal liability pero merong civil liability. Okay? So kapag kailan hindi mag-a-apply yung exemption, kailan naman hindi applicable? Halimbawa, kung may strangers na nag-participate sa pag-commit ng crime, tulad sa facts natin, si Vico, liable siya. Depende sa degree of participation niya, whether as principal din siya, or as accomplice, or accessory lamang ni Ion. Okay? Question number 89. Doctrine of fruit of the poisonous tree is otherwise known as A. Exclusionary rule doctrine. B. Taint doctrine. C. Legally obtained evidence doctrine. D. Silver platter rule. Anong sagot nyo, Miami Sai? Ang tamang sagot ay taint doctrine. Letter B. Iba pang tawag, but for test. But for test. Okay? Taint doctrine o kaya but for test. The test is whether or not the evidence could not have been obtained but for the illegal action of the police. Doctrine of the fruit of the poisonous tree means that once the primary source, yung tree, is shown to have been unlawfully obtained, any secondary evidence, fruit, derived from it is also inadmissible. Stated otherwise, illegally seized evidence is obtained as a direct result of the illegal act, whereas the fruit of the poisonous tree is at least once removed from the illegally seized evidence, but is equally inadmissible. The rule is based on the principle that evidence illegally obtained by the state should not be used to gain other evidence because the originally obtained evidence taints all evidence subsequently obtained. In short, Kapag ang ebidensya ay nakuha sa illegal na pamamaraan, hindi ito maaaring gamiting ebidensya laban sa akusado. Okay? Exclusionary rules. These are commonly used for evidence excluded by the Constitution. Halimbawa, evidence obtained in violation of the prohibition against unlawful searches and seizures. So, exclusionary rules ang tawag doon. Okay? Ano naman yung silver platter rule? Ang silver platter rule ay opposite ng doctrine of the fruit of the poisonous tree. Sa silver platter rule, an illegally obtained evidence is admissible in evidence. Kahit ng ebidensya ay nakuha sa illegal na pamamaraan, maaari pa rin gamitin laban sa akusado. This is not followed in the Philippines dahil what we follow in the Philippines is the doctrine of the fruit of the poisonous tree. Next question. Kaya pa, kunti na lang. 11 na lang, may homicide. Okay. Question number 90. Contra proferentem is otherwise known as A. Ambiguity doctrine, B. Parole evidence rule, C. Best evidence rule, D. Rebuttal evidence. Ang tamang sagot, may homicide, ay ambiguity doctrine. Contra proferentem rule is a doctrine which provides that in the interpretation of documents, ambiguities are to be construed against the drafter. Ito ay applicable sa mga contracts na kung halimbawa may provision sa contract na ambiguous o malabo ang nilalaman o ang magkabilang partido sa contract ay magkaiba ang interpretasyon. Ang interpretasyon na susundin ay against the drafter o laban sa gumawa ng kontrata. Okay? Ano naman yung parole evidence rule? Parole evidence rule forbids any addition to or contradiction of the terms of a written agreement by testimony or other evidence purporting to show that different terms were agreed by the parties, varying the purports of the written contract. Whatever is not found in the writing is understood to have been waived and abandoned. Ang parole evidence rule ay applicable sa mga written contracts. Kung ano ang nakasaad sa kontrata ng mga parties dito, yun lamang ang masusunod. This is the general rule. Maliban na lamang kung may kamalian o pagkalito sa written agreement o hindi nakasaad sa contract ang tunay na agreement ng parties o pinagkasunduan ng dalawang partido sa contract, in that case, as an exception to the rule, maaari nang mag-present ng oral evidence. Okay? So, ano naman yung best evidence rule? Ang general rule sa best evidence rule ay when the subject of inquiry is the contents of a document, the best evidence is the original document itself and no other evidence is admissible. So, ang rule, hindi admissible kapag mere reproduction, mere photocopy, or oral evidence sa best evidence rule. But in every rule, there are exceptions. Okay? Exceptions. Kung ang original ng document ay public record, pwede na ang certified true copy. Number 2, kung ang original document ay nawala o nasira na hindi kasalanan ng offeror, secondary evidence may be admitted. Ikatlong exception, kung ang original document ay nasa kabilang panig and despite reasonable notice, hindi inilabas yung original document, in this case, secondary evidence may be admitted. Fourth exception, kung ang originals ay voluminous, ibig sabihin sobrang kapal o sobrang dami, pwede nang hindi yun din lahat sa hukuman. Pwede nang i-present ang summary ng documents na yon. So, yung apat na nabanggit natin ay exceptions to the best evidence rule. Okay? Ibig sabihin, sa exception under the best evidence rule, yung secondary evidence ay pwede nang maipresenta sa korte at maging admissible in evidence. Okay? So let's proceed with question number 91. The following are not bound to appear and testify even if subpoenaed by the court. Except, maliban sa ano, A, members of Congress, B, ambassadors, C, witness who resides more than 100 kilometers away from his residence to the place where he is to testify by the ordinary course of travel, or D, a detention prisoner if no permission of the court in which his case is pending was obtained. Anong sagot nyo? Sa 91, may homicide. Ibig sabihin, kapag sinupina ng court, pwedeng hindi sila pumunta. Hindi sila magiging liable. Wala silang liability sa korte. Maliban sa ano? Letter A, except members of Congress. Kasi kapag members of Congress, hindi rin naman sila bound to appear. Pero dapat, the Congress is in session. Kaya naiiba dyan yung Congress kasi in case, halimbawa, adjourned ang Kongreso, edi pwede sila isubpina ng court. Okay? Yung B, C at D, ambassadors, witness who resides more than 1 kilometers away from his residence to the place where he is to testify or by the ordinary course of travel. Ito yung tinatawag na viatory right of a witness. Okay? Pag more than 100 kilometers nakatira yung witness, pwedeng hindi siya mag-appear. Okay? And yung letter D, a detention prisoner kung walang permission ng court kung saan may pending case si detention prisoner. Okay? So, they are not bound to appear and testify. So, ang answer is A. Question number 92. A child may be considered competent witness if he has A, capacity of observation, B, capacity of communication, C, capacity of recollection, D, all of the above. Okay? Qualifications of a witness who can perceive and perceiving and can make known his perception to others can be witnesses. Okay? They can be witnesses. Ang tamang sagot dito sa 92 ay all of the above. Kailangan yung witness may kakayahang magmasid, ipahayag yung kanyang napagmasid. Okay? 93. Malapit na. X testified that he saw A holding a knife while running from the place where B was found lying on his own blood. That A's hands are full of blood, and days after the incident, A fled from the Philippines. When these facts are taken together, they will show that A is the one who killed B. The facts illustrate A blank. Again, X testified that he saw A holding a knife while running from the place where B was found lying on his own blood, that A's hands are full of blood, and days after the incident, A fled from the Philippines. When these facts are taken together, they will show that A is the one who killed B. The facts illustrate A, letter A, direct evidence, B, circumstantial evidence, C, corroborative evidence, D, cumulative evidence. Anong tamang sagot? Ang tamang sagot ay circumstantial evidence. Okay? Ang circumstantial evidence is evidence which indirectly proves a fact in issue through an inference drawn from the evidence established. Ano naman yung corroborative evidence? It is an additional evidence of a different kind and character from that already given, tending to prove the same point. Halimbawa ng corroborative evidence. Ang mga testimonya ng mga testigo na ang ikinamatay ng biktima ay gunshot wounds may be corroborated by the death certificates of the victims. Ano naman yung cumulative evidence? It is an additional evidence corroborative evidence pala yun. Yung cumulative evidence, ang example ng cumulative evidence is testimonya ni A. Halimbawa, si A nag-testify kung sino ang bumaril kay B. So, yung testimonya ni A, kung sino yung bumaril kay B, ay cumulative sa magiging testimonya ni C kung sino ang nakita niya sa lugar kung saan nangyari ang krimen. Ang definition ng cumulative evidence is that Direct si X, nakita niya si A na binaril si B, ay direct evidence. Okay? Number 94. She witnessed the murder of Lucio. Nagalaw ko. Before the marriage of Sheila to Joshua, she witnessed the murder of Lucio by Joshua, but she never reported what she witnessed to the authorities. A year after the murder, Sheila and Joshua married. Barely 6 months after the marriage, Sheila became a battered wife, and to get even with Joshua, she served as a witness of the prosecution. May Joshua object on the testimony of Shusal if may testify for or against the testify ang isang asawa, affected spouse. Kaya bawal mag-testify si Sheila laban kay Joshua tungkol sa pagpatay kay Lucio. Okay? So that is the rule. However, there are exceptions to the marital disqualification rule. Number 1, kung ang testimony ay ginawa outside the marriage, anal na sila or may declaration na ng nullity ng kasal, eh di later on, pwede nang mag-testify yung dating asawa. Number 2, civil case ng spouse laban sa kanya, pwede. Ikatlo, criminal case na nakumit ng spouse laban sa kanyang spouse o laban sa mga anak niya, mga anak nito o ascendants o descendants. Basta criminal case. Okay? Ika-4, kung ang spouse ay ng consent, pinayagan na mag-testify laban sa kanya, no? Pero imposible naman 'yon, no? Ika-5, kung hindi nakapag-object ang spouse, kung ipresenta sa korte ang kanyang spouse. Si husband, si wife, rather, si Sheila, nung nag-testify, hindi nag-object yung asawa, si Joshua. So, na-waive. Hindi na niya pwedeng ma-question. But in this case, nag-object siya. Kaya, pwede niya pa rin ma-invoke yung marital disqualification rule. Okay, question number 95. 6. In all criminal cases, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. This statement is A, partially true, B, false, C, maybe, D, true. Anong sagot nyo sa number 95? Ang tamang sagot sa 95 ay false. Kasi ang tanong, in all criminal cases. Kasi not all. As a general rule, pag nag-offer ka ng compromise sa criminal cases, ito ay implied admission of guilt. Ang exception, may exception kasi, sa reckless imprudence cases. Kahit nag-offer ka ng compromise, sa reckless imprudence cases, hindi siya considered implied admission of guilt. Pero sa ibang krimen, implied admission of guilt. Halimbawa, nang rape ka, tapos nag-offer kayo ng 500,000 doon sa ni-rape mo, yung offer of compromise, para i-atras nila yung kaso, ay hindi nila in-atras. Yung pag-offer mo na yon ay pwedeng gamiting ebidensya laban sa'yo as an implied admission of guilt. Okay? Number 96. In which of the following reservation to file the civil action separately shall not be allowed? Kailan daw hindi pwedeng mag-file ng separate civil action? Sa ano-anong mga cases? Kasi generally, kapag when a criminal case is filed, yung civil action naka-attach na sa criminal action. But pwedeng i-waive, pwede ring magkaroon ng independent civil action, ibig sabihin separate mong ipa-file yung civil case, pwede yon, okay? Pero mayroong mga cases na hindi pwedeng i-separate, okay? Ano-ano yon? A, BPB lang 22 cases, B, cases cognizable by the Sandigan Bayan, C, tax cases, D, all of them. Ang tamang sagot, Miami Sai, ay all of them. Ang reservation to file the civil action separately shall not be allowed sa BPB lang 22 cases o bouncing checks law. Cases na under ng jurisdiction ng Sandigan Bayan at sa tax cases, bawal ang separate civil action. Okay? Let's proceed with question number 97. Malapit na tayong matapos. do you file the decisions of the ombudsman in criminal cases? Where do you file? Rather, where do you appeal? Sorry, where do you appeal the decisions of the ombudsman in criminal cases? A. Sandigan Bayan. B. Court of Appeals. C. Supreme Court. D. Department of Justice. Anong sagot nyo, Miami Sai? You have to appeal the decision of the ombudsman in criminal cases. Ibig sabihin, di ba, nagkakandak ng preliminary investigation ng ombudsman bago kasampahan ng kaso sa Sandigan Bayan. So yung decisions nila sa criminal case, natalo ka, mag-a-appeal ka sa Supreme Court. Okay? Letter C. Sa 98 naman, where do you appeal the decisions of the ombudsman in administrative cases? Admin cases naman. A. Sandigan Bayan. B. Court of Appeals. C. Supreme Court. D. Department of Justice. You have to appeal the decisions of the ombudsman in administrative cases sa Court of Appeals. Okay? Tandaan, Yamisay, kapag criminal cases, decisions of the ombudsman in criminal cases sa Supreme Court. Kapag decisions of the ombudsman in administrative cases, you have to appeal sa Court of Appeals. Naintindihan? Okay, let's continue, my Amizay. Question number 99. The two forms of arrest are by actual restraint of the person to be arrested, and the other one is A. By using force or violence upon the accused. B. By voluntary submission of the person arrested. C. Arrest by virtue of a warrant or without a warrant. D. Arrest based on probable cause. So anong sagot nyo, may Amisay? Ang tamang sagot sa number 99 ay letter B. By voluntary submission of the person arrested. So, tandaan, may Amisay, tandaan mabuti. The court acquires jurisdiction over the person of the accused by his arrest. And number 2, voluntary surrender. Yung voluntary surrender, katulad din ng voluntary submission. Okay? Tandaan mabuti yan, may Amisay. Okay? So, bago tayo mag-proceed sa question number 99, meron po tayong quiz mamayang gabi sa Law Enforcement Administration, 8:30 to 10:30 p.m. Okay? Imbitahan ng lahat ng mga criminology students and reviewees. And tomorrow, merong lecture si Ma'am Jinky Mazo. Itutuloy lamang niya yung kanyang backboard sa CDI kasi dahil sa last month, medyo choppy din yung recorded video, live video. And ano pa, sa June 25 at June 26, Law Enforcement Administration naman, i-discuss ni Lieutenant Colonel Enrique Agtarap ang ating panday. At ang ating board exam trial ay magaganap sa July 2, 8:30 to 10:30 p.m. 100 questions. Ang first prize natin, ang top 1 natin makaka-receive ng 500, top 2 ay 300, top 3 ay 200. Okay? Kung may tie, lahat ay bibigyan ng 500, 300 at 200 dahil meron tayong mga sponsors. Okay? And ang rationalization ay magaganap sa July 3. Ang magdi-discuss ay si Airport Police Officer John Aldrin Mayaw. Okay? So let's proceed with question number 100. Last question. Okay. In which of the following cases the judge is no longer required to issue a warrant of arrest? A. When the information was filed pursuant to a lawful warrantless arrest. B. When the accused is punishable by a fine only. C. The case is covered by the rule on summary procedure. D. All of the above. Okay? So, hindi na kailangan na mag-issue ng warrant of arrest ang hukuman when the information was filed pursuant to a lawful warrantless arrest. Kasi nakakulong na yung accused. Okay? Second, when the accused is punishable only by a fine. So, kung multa lamang ang parusa sa kaso, hindi na nag-i-issue ng warrant of arrest. Kung yung case naman ay covered by the rule on summary procedure like BP 22 cases, wala na ring warrant of arrest. Subalit, tandaan, Miami-Sai, kung ang accused ay hindi umattend sa arraignment or sa hearing, di ang gagawin ng fiscal dyan, move siya sa court na mag-issue ang korte ng magpalabas siya ang hukuman ng bench warrant para arestuhin ka. Okay? Pero kung umattend ka naman sa hearing in ABC, hindi ka na kailangang pang-issuehan ng warrant of arrest. Okay? Sa summary procedure at kung fine yung penalties mo. So ABCR